then we will get started. Make sure I'm muted. There we go. All right, let's be on the record in case number 2015CR873, captioned State of Kansas versus Mrtez Blakney. Would the parties announce their appearances, please?
Your Honor, may it please the court, State of Kansas appears by Assistant District Attorney Daniel Obermeyer.
May it please the court, defendant appears with counsel via Zoom, David Winery.
All right, we are here set down for a sentencing. This case has had kind of a long and unusual path through the courts. The plea was actually taken back on November of 2015, and it was in Division 8. I can't tell you who was in here in 2015, whether it was Judge Burns or Judge Clapper, but in any event, the defendant pled guilty to the count 1, which was possession of marijuana, which was a severity level 5 based on the prior conviction for that. So the judge ordered a pre-sentence investigation, but in the meantime, Mr. Blakney ran afoul of the federal government and ended up in their custody for an extended period of time. He was only recently released, and I believe is residing in a federal halfway house at this time. He did try and file a disposition of detainers. Unfortunately, being held in federal custody, he was not eligible for that, and Judge Clapper so found. So he got out. We have this PSI done reflecting the new criminal history based on the federal charges, and we're ready for sentencing today. So speaking of that pre-sentence investigation, the critical findings are as follows. The sole count of conviction is one of possession of marijuana. Again, based on a previous conviction, it is a severity level 5 non-person drug felony. His criminal history score was found to be that of A, as in Adam. That would leave him with a presumption of prison and a presumed underlying range of 37, 40, or 42 months. If he has to do that time, he'll be eligible for 20% good time credit and subject to 12 months of post-release supervision. If he's granted probation today, it would be for a period of 12 months to community corrections. I would ask you first, Mr. Obermeyer, did you have a chance to review the PSI? Any additions, corrections, or challenges to those findings?
No, Your Honor, the PSI appears to be correct.
All right. And Mr. Winery, same question.
Yes, Your Honor, it's correct.
All right. And you had a chance before we went on the record today. I know that this kind of came in at the last minute to go over it with him, and he has no challenges to those findings.
Yes, Your Honor. Yeah, we got a chance to go over it, what the person felonies were and why he was an A.
Okay. Fantastic. Then I will adopt for today's hearing the findings of the PSI. Mr. Winery, I know it's your intent to get filed today a motion for a departure in a written form. Would you like to make an oral one at this time?
Yes, Your Honor. I would just like to point out that while my client was in federal custody, he was in a treatment program. He continues to be in a treatment program and will be on federal paper for another 2 years. And this crime of conviction was also a lot less severe than would normally be under the circumstances. And we would like to ask that those be the departure criteria, Your Honor.
All right. Mr. Obermeyer, I would hear your comments on the defendant's motion and anything else touching upon sentencing today.
The state would leave it to the discretion of the court as to whether or not impose probation in this matter, Your Honor. For purposes of an underlying sentence, the state would request the court impose the standard sentence of 40 months.
Thank you. Mr. Blakney, now's your opportunity to tell me anything you want me to know in mitigation of your sentence today.
Well, Your Honor, I've been doing good on federal paper. I've been going through, like I said, I got to an MAR every Wednesday. I go to group like I got like individual meetings that I gotta go to. Like I said, I've been staying out of trouble. Been trying to do everything I'm supposed to do. It's just been hard.
All right, thank you. Mr. Winery, do you know any legal reason why I should not now proceed to sentencing?
No, I do not, Your Honor.
All right. Well, I am going to grant the departure. Here's a couple of reasons why, as defense counsel noted, Mr. Blakney has been in federal custody. He has availed himself of programs and treatment that should help him be successful on probation. He has served a period of time in federal custody. And I think that giving him an opportunity now, with hopefully being in a completely different place than he was 6 years ago, that he would be able to be successful on probation. So I will adopt as substantial and compelling reasons those argued by defense counsel today, and that will appear in his written motion, and the findings that I'm making myself, that the defendant, there is a program available to him and he is eligible for it as noted by his comments, and that it would serve defendant reformation better than, and public safety better than, a prison sanction. Therefore, for the sole count of conviction, possession of marijuana, a severity level 5 non-person drug felony with a criminal history score A, the defendant will be sentenced to 40 months in the Department of Corrections. If he has to do that time, he'll be eligible for 20% good time credit and subject to 12 months of post-release supervision. For the reasons set out before, I will find that I am considering the defendant's application for probation and granting the same to community corrections for a period of 12 months. Specific terms of his probation are that he successfully complete his federal probation and supervision and any conditions thereof. If he has a treatment follow-up, a substance abuse treatment follow-up plan, he must follow that and any recommendations of that treatment. Mr. Blakney, since you've been out, are you employed?
I'm getting disability, Your Honor.
What's your disability?
A disability. Right now we fighting. I just got denied, so I got a lawyer named James Green. So they just sent me my papers where they told me that they'd be contacting him and not me. So that's what I'm fighting right now.
All right. So you're not actually on disability. You're applying for disability. Is that correct?
That's right. Yes, Your Honor.
And what can you tell me what the disability is that you're claiming?
I've been shot 12 times, Your Honor.
Okay. And it's physically left you without the ability to work. Is that correct?
Yes, Your Honor.
All right. Well, then I think I'm going to take it easy on you here. I'm going to assess the court costs and supervision fees because I think that's something that you can pay over the course of your probation. I don't believe that you need to be assessed the KBI database fee because it's apparent that you have prior felonies and that they have their your DNA on file. So that won't be necessary. I'm not going to fine you. You've retained your counsel, so there's no appointment fee. So it's just going to be that court costs and supervision fee. That's going to come out to be about $300. So if you're on probation for 12 months, you're probably looking at, what would that be? $50 a month would take care of that. Probably even 25, but I'm gonna, if I ordered you to pay $50 a month towards your probation or towards your costs and fees, is that something you could do, Mr. Blakney?
Yes, sir. Yes, sir.
Then I'll make that the order, $50 a month. That'll get you paid off before your
And
probation is up.
may I ask one other question, Your Honor?
Yes.
Will he be primarily supervised through the federal government so he's not duplicating both terms. of probation?
Here's what he's gonna need to do. He's gonna report initially to community corrections, inform them that he's on federal probation. They will communicate with the federal authorities. And if they agree to courtesy supervise him, then he'll only have to do the one. And my expectation is they do that all the time and that it shouldn't be an issue. But he needs to initially make contact with community corrections. All right. All right. So Mr. Blakney, there's a few things I need to advise you of before we break here. You have 14 days from today to appeal anything you don't like about your sentence. And you may be able to seek expungement of this conviction after a period of time following successful completion of probation. As a convicted felon, it's prohibited for you to own or possess a firearm and certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons. Do you understand all that?
Yes, Your Honor.
Okay. All right. Then, Mr. Obermeyer, I would ask you first, anything that you know that I failed to cover today?
No, Your Honor, but if the state may make a motion to dispose of the property seized, in this case, specifically the narcotics.
Any objection, Mr. Winery?
No, Your Honor.
All right, granted. All right, and Mr. Winery, anything else I failed to cover today?
Nothing, Your Honor.